Good morning and good afternoon. For those of you that don't know me, I'm Alice Mount and I'm the Director of Strategic Partnerships and Events at British American Business. It is my pleasure to welcome you to today's very timely webinar on overstaying in the USA and looking at the tax and immigration considerations for business and intermittent travellers. Just one house rule, we want to leave time for Q&A, and I encourage you to send questions through that Q&A function at the bottom of your screen, which we can pick up and bring into the conversation. And if I can, I will call on you to ask your question in person, and we'll give you the microphone and screen, and we'll do that behind the scenes. So do flag up questions in the Q&A function. Many of our member companies have colleagues and clients that travel overseas regularly, and I have not seen this level of disruption to business and personal travel in my lifetime, as I'm now seeing from COVID-19. Yesterday's proclamation from the White House makes today's webinar all the more timely, and I want to thank in particular Charlotte Slocum from Fragaman, who's rapidly digesting the implication of this newest proclamation. I've only glanced at the document and I can already see what a huge impact it will have on our members, and B&B's own exchange visitor program that uses the J-Choney visa. Today we're bringing together two partners, Frank Hirth and Fragaman, to cover those tax and immigration perspectives and address the concerns affecting particularly those business travelers that have overstayed in the USA due to sort of staying grounded in one place for COVID-19. Michael Lewis is a director at Frank Hirth with over 21 years in the field of personal tax advice. And Charlotte Slocum is a partner at Fragaman, responsible for the consular teams and the documents teams throughout the EMEA region with in-depth knowledge and expertise on the US business visas. The British American Business team is here for our community in good times, and more than ever we're here during the challenging times. So thanks to everyone on this session today. It shows us that what we do is relevant and timely, and that is our job and mission. And let me give a very warm welcome to Charlotte and Michael. I'm delighted to hand over to you, Michael, in the first instance to start the discussion. I'll be back to help moderate some questions from our guests. And just a reminder, keep using that Q&A function during this discussion. So over to you, Michael.
Yeah. Thank you, Alice, for the introduction. So I guess to kick off, we should probably just go through those categories of people that we think this sort of presentation is and discussion is most relevant to. I've sort of identified sort of 5 potential groups of people that I think we should talk about, and I think we can, for the most part, we can group them all together. But first off, we sort of have the sort of ultra wealthy itinerant travelers who just spend their life on the move, who may have holiday homes in the US and have chosen that location as the location that they will base themselves during this present crisis, and may therefore end up spending more time in the US than anticipated. And of course, they may be based in the US either voluntarily or involuntarily, because of course, involuntary in relation to the fact there may not be flights available to where they would usually live or reside. Then we have employees working with US-based teams on projects, and maybe they were working on this project immediately before the crisis. They decided that they wanted to get the project started. They've now decided to stay in the US, work on that project with that US team, and what that might mean if they're still there. We've got assignees in America who maybe they were expecting to come back. Maybe they were a short-term secondment of 6 months or a year, and now that's not, they've stayed there because of the uncertainty. They don't know if they leave, whether they can come back again. We have the transatlantic commuters who maybe commuted regularly across the Atlantic, residing perhaps in the UK but working in America, but have now chosen actually they will base themselves near their employer. And then finally, we've got this sort of senior execs who can base themselves anywhere because they run their own business, and decided actually they would base themselves in their nice second home, potentially somewhere like the Hamptons for the summer. And all these people, because of this sort of crisis, are potentially spending more time in the US than expected. Maybe they're stuck there. Maybe they feel they can't leave because they don't know whether they can get back, and they therefore have issues. I mean, I guess that I'm going to hand over to Charlotte to maybe talk about some of the issues, especially this is very timely given the proclamation yesterday, and particularly as to fears that if you do leave, you may not be able to get back. So So Charlotte, what actually happened yesterday?
Well, I'll take it back for one moment to kind of look at your kind of different classes there. So I think that the main question that you always need to ask is, what is the visa class? And does the person have a visa class in the first instance? Because that will depend on how you deal with them as a group or as an individual. Equally, whether they can be subject to an exemption through a family relationship. So there's there's multiple proclamations, but there's two that we'll talk about today. One is the travel ban, which impacts, which came out in April, and that is essentially the ban on all Schengen countries, including the UK and Ireland. China came before as another proclamation, but we'll just kind of include them in the kind of broader travel ban population. Brazil came later, again, they're part of the group, and Iran. So any of those people that are physically, it's not about nationality, to be clear, it's where they're physically located, are subject to the travel ban. So every single person on this call who is physically in the UK at the moment is subject to a travel ban, except if those that are married to a US citizen or have some of the other, fall under this other exemptions, essentially diplomatic or crew, and that those sort of exemptions, which I won't go into massive detail because it's probably not relevant for this call.
Although, just a side shot, I did see that Nigel Farage, didn't he get to go to America at the weekend?
I think that will, it depends on the visa he's on, because diplomatic visas are, it depends whether he holds an A or a G visa. Also the reason for him traveling. So I'll just kind of take a step back in the sense that you've got that proclamation that you have to deal with, so the physical travel ban component, and then you've got the recent one which is more geared towards the unemployment rates. So that's less to do with where you're physically located and more to do with the actual visa that you're looking to obtain. So this travel ban means that anybody physically outside of the US at the time that it becomes effective, which is tomorrow, who need to apply for a new visa, so it don't have an existing visa, would be subject to this proclamation. So what I mean by that is people that don't hold an L visa, which is an intercompany transfer visa, don't hold an H visa, which is a new hire visa, don't hold a J visa, which is the intern, trainee, researcher, scholar, that particular type of visa. So it essentially, I guess you need to kind of look at it in buckets and look at each individual person and see whether they're subject to multiple proclamations or one. But if you look at the heart of this, the only way really to get a visa in this current climate, because all embassies are closed as well, I probably should have started there, is that every single US embassy in the world is not processing standard visas. So that is separate from the proclamation as well. So you have to go through multiple hurdles to even have any chance of getting a visa at the moment.
What happens if your visa's coming to an end then? I mean, can you renew?
If you are physically in the US, yes. And if you have an existing visa, yes. Where it becomes a little bit more complicated, where we will need to go into this in greater depth and seek clarity on this point, is whether if you're looking to change visa class. That's where it's a bit tricky, because the proclamation is not clear. It makes reference to NIV class, lumping them all together, and that could mean a B visa, which is business visa, or it could mean a student visa, and it's whether you can switch from a student into a work category is not clear at this point. It just makes reference to you holding a visa. Yeah.
Just one quick question and clarity from the audience. For US citizens, they're still allowed to go back to the US at any time, aren't they?
Yes, they're not subject to any of the proclamations. They're specifically excluded, and that includes green card holders as well, and spouses. So yeah, so what we're doing at the moment is a lot of waiver requests. So that's like a public interest waiver. So essentially we're building a case as to why these people should be granted a visa in exceptional circumstances, because they meet the standard of in the US public interest. So obviously the threshold is very high, and at the moment it tends to be COVID related. So for example, that they're looking at working on a vaccine, which is current one that we've got, or a real humanitarian need, for example, life and death type situation. So they're the ones that are meeting the waiver standard at the moment. But actually your question, Michael, right at the beginning is in terms of if people are overstaying, that's more linked to another procedure again. So I don't know whether you want to maybe go into that on your side a little bit more.
Well, I guess, well, before I do, what is if someone does, let's take the visa waiver program, like, which I think is it 90 days that you can spend in?
Yeah.
Let's say someone spends, it is now at 95. What bigger is that? Does that mean that they're done for when they get kicked? If they found out they get kicked out and never come back, or what actually does that mean?
Well, it could mean all of the above. What you need to have done is filed a satisfactory departure filing with one of the CBP's ports. So basically wherever you came in, so say JFK, you flew into JFK, before that 90 days hit, you need to have filed a satisfactory departure. And that will be based on some sort of argument you can't physically get back on a plane. So they're highly discretionary. JFK seems to be kind of been pretty good actually, but all ports will vary, and you need to build a case as to why you couldn't get back on a plane, essentially. So obviously evidence of cancelled flights. We have one example of that people have medical conditions that would concern them to get on a flight at the moment. But one thing to be really clear on is, up until the regulations are changed or there's any clarity on this point, anybody that is overstaying ESTA, even for one day, loses the privilege forever, even if you file a satisfactory departure application.
Right. That means they would need to get a visa next time, which of course you can't get.
Correct.
Yeah.
Yes.
Okay. And I'm sure is there any indication when this might change from the, in terms of hints in the proclamation about when things might be relaxed?
Well, there's multiple proclamations, so I guess it depends on which one you're looking at. I think the one where there's we'll call it the Schengen travel ban. That one I suspect is there's greater link to the health component there, and potentially travel bubbles, etc. But this is a guessing game. You're kind of this is crystal ball gazing. It's very difficult to kind of know what's going to happen, but it's likely linked to the health piece and numbers and what's going on the ground with each individual country. For example, the UK came later after Schengen, the same for Ireland, and it might be that there's an agreement that's different from the Schengen area. So that would cater for the ESTA travellers, right? So I can only enter the US at the moment for ESTA, but because I'm physically in the UK, I'm prevented from doing that. If I were to spend 14 days in Mexico, for example, right now, that hasn't got a travel ban, I would then be able to travel into the US under ESTA, right? That's very different from the other proclamation that's just come out. If I was looking to work in the US for Fragment US, I couldn't physically get that visa now.
Yeah.
So that's different, even if I was in Mexico for 14 days. So again, you need to parse all of these out differently and not lump them in together, because they're, the one individual can be subject to multiple, but yeah, unless you break it down, it becomes really a little bit too complicated.
Okay. I mean, I think the tax, by comparison, is a lot more straightforward, particularly some of the reliefs they've given, which has actually been helpful to individuals and not hindrance. So for people overstaying, there's sort of three sort of tax issues they need to think about. Firstly, have they potentially triggered residence, or might they trigger residence in the US? What that might mean from a global tax and also a global reporting perspective, because the US has very stringent reporting requirements on worldwide assets and income. Secondly, whether even if they're not resident, they've actually picked up an additional tax charge if they're doing any work in America, even if they're working remotely, that's regarded as work. And thirdly, whether they created any corporate tax issues for their employer, particularly in respect to creating a permanent establishment, depending on what they're doing if they're based out there. Now, those are the sort of three issues we sort of commonly see for people overstaying. The first of those issues, residence, just a quick summary, that the US has a test for non-green card holders and non-citizens, which is based on a 183 days in the US. And this is based on current year days, 1/3 of the prior year, and 1/6 of the preceding year. And when you add those together, you get to 183 or more, you're US tax resident. Now, that actually equates to about 100, on average, 120 days a year. So you might hear it said that a rule of thumb, 120 days a year you can spend in the US. Now, this crisis has been going on 3 months. Someone actually may have spent more than 120 days in the US last year. And if they were relying on this 120-day sort of rule of thumb, they might now well actually be approaching it or actually have exceeded the relevant threshold and have triggered residence already, or at least they would have done. Now, one of the things which helpfully happened, which a month ago, was that the IRS published some guidance which basically said, look, because of this crisis and because people can't move between locations, individuals can choose a 60-day consecutive period, up to 60-day consecutive period, when they're in America, between the 1st of February and the 1st of April. So that's the start of the period. And they can exclude up to 60 consecutive US days out of, from this test. So for instance, if they had a consecutive period in the US of 45 days starting in February, they could exclude 45 days from that 183-day test I mentioned. And so that means, essentially excluding 60 days significantly helps people to get under that 183-day threshold, and means that much less risk of being tax resident. What they also said was that exclusion also applies to working. So if you do work in America during that period that you're excluding for residence purposes, you can then also exclude the work you do from tax. So if you're working remotely, the US will look to tax you on your employment income by reference to that work day. So that was helpful. Then they also said that during that period you choose to exclude, the US won't look to say that you created a permanent establishment. They just ignore that period and ignore what the type of activity you're doing during that exclusion period. Now, this is just, it doesn't mean they look outside that period though. So if you have, if you 60 days, this crisis has now been going on much longer than 60 days. So that means they could well still be doing major activities which are creating a tax charge for themselves. They could still be now facing residence issues, and they could still be creating a potential permanent establishment, albeit there is this rule of thumb which says you can exempt up to 60-day period from these tests, which is helpful but not conclusive. So I think the US tax position has been significantly helped by this relief, which has been was announced a month ago.
Thanks, Michael.
But I think one of the questions I have for you, though, one of the things we've seen as well is that although there's no tax charge on, let's say, someone working remotely, at least during that 6-day period, what if, Charlotte, what are they actually allowed to do work-wise? Because they may have gone to the US. I don't know. Let's take the category of the senior execs isolating in their second homes in the Hamptons. They may have just be used to doing this because they regularly go to holiday. They regularly go to America, and they typically answer emails or just look at their phones when they're on holiday. But now, of course, they're now based there, potentially running businesses. Is that okay? Particularly if they're on a visa waiver.
I mean, it depends on it depends on whether they have a visa or not. On the assumption that they don't and they're there for visa waiver, this is a very grey area because you shouldn't be doing productive work in the US. So, I mean, you could argue that productive work is associated to a foreign entity, and obviously you keep your kind of the actual salary. Your salary is actually still paid out of the foreign entity itself. So there is some, not really provision, but there's some kind of latitude around that piece. But where it becomes, you need to be very, very careful is where you are working effectively for a US company. So it's not just the salary piece. That's kind of a little bit of a myth. It's also not the length piece. It's what ultimately the activities. So are those activities generating income, for example, for the US company? Do you have in your signature? I mean, this is a general thing. It's got nothing to do with COVID. Hang on, let me close my window. It's not got nothing to do with COVID. It's, what are the activities that are permissible under the ESTA category, and essentially, anything that would be kind of doing productive work, you're at risk. Even down to if you're commonly a trainer or you're a consultant and you're going to the US and you're kind of earning income, the company is earning income from the work you're doing. Again, that's kind of productive work. So there definitely is areas of grey. If you're still sat in a hotel room, ultimately working for the foreign entity, then it's a little bit cleaner. But the longer you're going, obviously, the greater concern there is, because pre-COVID, what the immigration officials look at is your pattern of travel, right? So they'll say, how often is this person going to the US? For how big a chunk of time? So if you went for 1 week every month, it might not attract attention for the first couple of months or the first 3 months. But if you're doing that over a period of a year, it's likely to start attracting attention. I can't say that I've had people that haven't, have always had issues in this context. There are people that manage to do it, but it's getting away with it as opposed to, and CBP not picking up on it. So it's kind of a very dangerous strategy to kind of rely on that. So my rule of thumb is if you're spending more than a week a month, it will create concerns for me. So CBP will look at, is this person essentially working? So the best way of looking at it is, if you were that officer, do you think that person is spending so much time in the US, how could they possibly not be working? So then it goes full circle around to your point. If you're going over that 90 days, then it starts to get concern. I mean, I wouldn't want to max out anyway under ESTA pre-COVID. So I think you'd have to have a really, really good reason to be extending, and it has to be that you physically cannot get a plane. And right now, okay, in the height of COVID maybe, but right now I would have question marks as to whether you could make that argument and not just simply get a plane, even if it's multiple stops. So, for example, I wanted to get to France, and it's probably like 2 or 3 stopovers, which is excessive. But the point is, I can if I really wanted to. So that's the, convenience is not going to be an argument here. It's that you physically cannot get on a plane for a reason. And I think the argument lessens as airlines start picking up. The one thing to remember, back to my earlier comment about ESTA being taken away from you, it has this knock-on impact, right? So it means you can't go on holiday anymore under ESTA. This is not just a work thing. People often kind of say, don't realise that this has a personal impact on your personal travel. So I certainly wouldn't be looking to extend ESTA unless there was really, really good reason. And I would, that's very different from somebody that's actually holding a visa, where you could look to extend their visa class. And there are some concessions the RFE rate, which is request for further evidence, which is a common thing that happens when you file for a work permit. They have been extending how long you can, how long you've got to reply back. So there are some concessions, but it doesn't sound like they're as significant as, for example, the tax ones.
So someone approaching that 90 days should get out ASAP, basically, any way they can. It strikes me that even if they're not in the 90 days, depending on what they're working on, I know it's not based on length of time, but in my mind, the longer you spend there, the more likely you've got to be doing productive work.
Exactly.
Particularly if you're senior, they're not going to pay you for just, for minor admin. They pay you for adding value to the business. So, and I know there's this argument that it's maybe an overseas business, but most operations, most businesses have operations in all just jurisdictions. So it's hard to really divide up where the benefit of your work is. So they should be probably pulled out ASAP if they don't have a fully recognized, visa.
Yes, I would like that anyway as a general rule, but yes, essentially that's accurate. The one thing we missed probably right at the beginning is that, correct me if I'm wrong from your side, but tax always seems to be a little bit more black and white, as in that there isn't this huge level of discretion. I might be wrong, but that's kind of my historic interpretation.
Exactly. Work is work. So it doesn't matter what you're doing.
Yours is based more on the physical physical presence piece, whereas this is more a subjective analysis that can vary by person, right? So, and this actually underpins the whole of the US immigration system. It's completely different from the UK system, which is black and white, it's objective, it's points based, right? You build up your points according to criteria. This is based on subjectivity, and that includes business visa travel. It's a lot more subjective. There's a lot more discretion. So what you'll find is different embassies will treat things differently. Different what they call USCIS, which is basically the Home Office, that will treat things differently. So you could have the same filing, exactly identical people. One gets the visa, one doesn't. And CBP, which is the guys at entry, there's massive differences. So I think throughout this, I think it's really important for people to bear that in mind, because I remember talking to a consul general once, and they said essentially they're not in the business of creating transparency for businesses. So that's not what they're there for. So it does give this level of business uncertainty. And of course, then these proclamations are adding to that substantially, where, what is the public interest? How do you work out public interest? Is it purely on loss of jobs, or, do you see what I mean? So it's all very much dependent on who you're approaching.
There's no doubt tax is much more objective. The residence test is based on any part of a day as a day. Work day is based on, are you working? Are you being paid for the activities you're doing that day? It doesn't matter what they are. Are you being paid for the activity? Then it's work, and it gets taxed unless you get a treaty relief. Much more easier. On the tax side, one thing I didn't mention was, obviously we talked about federal exemption. This relief I mentioned is on federal taxes. So of course, US is a federal system which has states which have their own tax systems. So some people may be creating state liabilities as well, which need to file. Now they may not be incremental tax charges because they may well be able to get a credit, but it does mean extra filing requirements as well for such people. So, there are, I do think probably the immigration issues are way more serious than the tax because of the long-term implications of someone exceeding their visas, but there certainly are major tax issues still out there, even notwithstanding this sort of 60-day relief the IRS announced a month ago.
I mean, one thing just to close out on, I mentioned if you overstay by 1 day, it has this knock-on, and obviously that will include people that are on visas and not on visas. Anybody that overstays their period of stay, there is an impact on ESTA travel, and equally there may be issues in reapplying for a visa. So it's the one thing though to note. I don't know whether we'll hit that problem or not, but anybody overstaying over 180 days is then barred from the US for 3 years. So that's substantial. So that is one thing to it's really important to kind of keep an eye on those days.
Okay. I saw we've got a couple of questions, Charlotte. One of which actually is a reverse question. It's like, what if you had a US citizen who's in the UK on a UK visa? It may not be a question that you can answer. But if they get, is there a UK issue if they're not spending enough time in the UK because they're stuck in America?
It's a good. I can take that away. Despite my accent, I'm actually a US immigration expert. Mm-hmm. I'm not aware of there being any. I think it depends. Yeah, I'm not aware of there being anything, but I can take that away and kind of find out from my UK colleagues.
Okay. And then someone, I think we've kind of maybe have answered this in the general discussion, but they've asked if someone who works for a UK firm is on there on holiday, although I'm not quite sure how they got there, for 2 weeks, and then works there for a week, is that excessive or not excessive? Is that a problem? I mean, I think one of the contexts of this is that we're seeing in Europe, maybe not in America, is that I know clients are asking me, what if our employees tag on work to their holidays?
Yeah.
And maybe it's not relevant to America yet because of the travel ban. But what if people did that? Is that a problem?
Well, certainly the word work is a problem. That's very different from engaging in business activities. But it's basically going full circle to what we were talking about originally, is what does that work look like? What does it mean? What do you mean by work? But a week probably won't. It's all about balance of risk. But having said that, if you're a celebrity on a no, then yeah, probably. We have had issues in the past where, somebody's been a catwalk model and they've entered under ESTA, and then years later, the embassy Googled them and realised that they were working on an ESTA.
Well, there are special rules for entertainers and sports people as well. It's worthwhile saying. So they sort of have a whole different set of tax rules where you get sort of specialists advising on it. Generally, I think for a week, for a tax perspective, I probably wouldn't think that there's a problem. It's probably going to be covered by the treaty in any case, but it might be a state tax filing requirement for that.
Yeah, practically speaking, it probably won't be. You just need to. The big thing as well, of course, is whether you, kind of misinterpreted your intentions to immigration upon entry. That's very different from things potentially changing when you're in country. Do you see what I mean? Because there is a difference there. It's, they ask you a question of why are you here, and that needs to be true upon that entry. That is slightly different if things change when you're there. There is a difference between the two.
Yeah. So, I guess,
Alice, have I don't know whether I went into enough detail on the proclamation. Is there anything that you kind of want me to delve in
I'd
a
very
little
much
bit more?
appreciate if you could use, because it's so timely with it coming out yesterday, if you could talk us through sort of what you and your colleagues and peers are looking at in terms of interpreting it. And so this is going to last through until the end of the year, the calendar year.
Yeah.
Just sort of in layman's terms, just tell us exactly what this will mean for businesses who were about to sort of recruit or move employees over to the US. Can they use with more and more people working from home and remote work, will that not be a solution for a lot of companies who can still do virtual teams to sort of overcome the requirement to be physically present in the US?
I mean, that's a good question. It's probably not an immigration question. The last one, that's more kind of a company management. I do, and agile working, etc. And I do think potentially that is a solution. Where it becomes very tricky is where you've got manufacturing businesses, for example, and not all businesses can work remotely, right? So that's where it becomes more tricky. But to answer your kind of original question, it's essentially the 3 visa classes that's impacting is the J, the H, and the L, right? So the J's are the interns, the trainees, probably potentially not as much of an impact on the audience here. They're the exchange, the kind of the Camp America type. I happen to have done a J, actually how I got into US immigration in the first place in 2001. But it's, kind of intern related. So, but the one that's going to impact the US the most is the H and the L, because they're the highest visa classes. So it will be very interesting to know whether it impacts, switch in-country switches. I will need to kind of a different visa class. I think that I'll need more clarity on that particular point because it's not clear. But so think of it as more impacting new visa applications if somebody's physically outside the US. So you've got 2 populations here. You've got your staff already there, and you've got your staff, your future staff, that you would like them to get a brand new visa and they haven't had a previous visa, or they haven't got one at the moment, I should say. So I think the best way of doing it is separating out the 2. So long term, particularly the L, which is the intercompany transfer, it will, it will hurt big business for sure, because that's the one that they avail themselves of the most, the L1. So I guess, I mean, in terms of strategy, I'd be looking to see whether there's any nexus, industry nexus to COVID. For example, a lot of, there's specific mention to the food industry. There's mention to, science, and, medical industry. So I'd look to see whether there's an exemption of some kind or an economic interest. So what I'll be probably looking to do is try and build up arguments around the economic need for particular individuals. The problem is you then have to take one person by one person and do individual applications and kind of see whether you can get them in. But yeah, no, I think it will. It's definitely going to be tough on businesses, and we shall see. I suspect this may lead to potential lawsuits. Who knows? But it's going to be tough times for sure. So the one important thing is to know where your population is, plan ahead, because a lot of embassies at the moment, you can't book an appointment, as in they're not processing visas, but you can book appointments, but the next available appointment is September. So it's really important, for example, in London, it's really important to plan ahead, start kind of talking to your immigration providers as to whether there's an argument that you can build. Does that answer your questions?
That's very helpful. So, and I think certainly on behalf of British American Business, we'll be looking to our members for some feedback on how this impacts them, and what we can say on behalf of the community. And we do have a question from Babu Bangaru, just asking if this proclamation will likely impact other visa categories like the treaty investor visa, the E2 visa.
Oh, that's actually a really good point, which I did want to raise on this call. This is not including the E visa class, which I love. I love the E, because the criteria, of course, is that the business has to be majority treaty owned country. So what I mean by that is, if we take the UK by way of example, it needs to be 50 plus owned by British nationals. If you can meet that criteria and the person you're looking to send is equally British, you can't have a mix of the two unless you have a joint treaty. So if you had 50% owned by German, 50% owned by Brit, you could potentially be bringing in German and British nationals. But to keep it simple, if it's 60-70% owned by British nationals, then you could bring in a British national. While the embassy is not processing these within the Schengen area because you're subject to the other travel ban, this particular proclamation does not deal with the E. So at the moment, in terms of strategy, I really, really recommend that you be looking at whether you're E eligible as a business, because that will be a potential option, and that means that you might be able to get people in before the end of the year.
Michael, were there any other points that you wanted to sort of touch on? Any case studies, case examples you could give us of individuals that have been stuck in the US that, and is there a state-by-state difference as well, according to,
yes,
so there's a lot of domestic travel going on in the US, and Charlotte's mentioned you can sort of also get around using other neighboring countries to perhaps consider entering into the US. But that does sound like it has some risks attached to it as well.
It does, yes.
I mean, you know, to give a real case, I have been advising in respect of SO, you know, some senior owners of major UK businesses and their families who have based themselves up there. Now they have like chairman roles in one case, and they've not heavily involved in day-to-day management, but are still involved to some extent. But they've based themselves in America. They were there predominantly not to work, but we know they're doing work, and we know that they are potentially triggering residence if they, you know, considering the amount of days they spent in the US in prior years. And we know that they potentially might create a permanent establishment if we look closely at what they're doing. So there is real, you know, this is not just a theoretical. There are people who have decided that America is a nicer place to experience lockdown than the UK. And, you know, so we're advising them. In respect to the state's point, it's very important that people understand that state taxes are, you know, are independent of the federal. And even if they get relief for federal, that doesn't necessarily mean that you get relief for state. And that also applies where double tax treaties apply, because many states will not accept either through fact or even through default a tax treaty relief. So there could well be state tax liabilities. Now I had a quick question, just Charlotte, I mean, about this kind of difficulty of traveling. Can you, can you sort of reset any kind of visas by just popping to Mexico or Canada and then coming back again? Is that possible? Sorry, on mute.
Sorry, am I unmuted now? Yeah. It depends on what you mean by that exactly. If somebody's already on a visa, an existing visa, can they extend their visa if they?
Well, I meant more on the, maybe back to the visa waiver program. If someone's at, 85 days, can they do a new period of 90 days?
No, not if you're it's within the common travel kind of area, so that includes Canada as well. So unless you specifically ask to get a new I-94, it's with you basically keep the same period, but that's very, very dodgy strategy as well. Like, as in, you're very likely to have a problem at port of entry if you kind of get to 89 days and try and get back in for another 90. They're going to clock what you're trying to do.
Yeah. Okay.
So, yeah.
And Charlotte, a question for you from our CEO, Duncan Edwards. Do you think that it's likely there will be retaliatory action from the EU or the UK on visas for US citizens?
That's a question. I'm not sure. I don't know. I probably would have to have a chat with my UK colleagues, but there's not been any noise around that, but obviously this is fresh off the press stuff, so who knows. I mean, quite often there is reciprocal there is kind of reciprocal kind of treatment in previous type of situations. There has been, depending on the country, but that's more political, so I'm not sure. I wouldn't know at this point.
And just scanning some of the news feedback on yesterday's proclamation, it seems that there may be a move to, when the H's are sort of reintroduced, that it will be based on the highest salaries and sort of getting the first quota of them, and so organised by salary amount, not the sort of more randomised application procedure or the lottery.
There is talk in the proclamation to review, but it doesn't give any details. So I'd probably be hesitant to kind of read anything into the press comments at the moment. Yeah, I mean, there is some reference to that, but that could take any connotation. There just is mentioned that there will be a review. So having said that, there was a big change with the H's recently. So, and they're not easy. They're not easy to get at all. So, yeah, no, I wouldn't be able to comment much more about that, because obviously it would be a little bit too crystal ball gazing on that one.
And when do you sort of, I presume Fragment will be putting out some more thought leadership on this once we've had more time to digest what it means and look at how it's being interpreted, as there seems to be some uncertainty around the language. So we'll sort of track what you have to say and sort of share that with the network as well in the days ahead.
Yeah, there's a microsite as well, so there's a lot of information there.
Great. Well, if we don't have any more questions from the audience, just any final words from you, Michael and Charlotte, before we wrap up today's session?
No, I just will add that, in something I didn't add before, but in addition to this deemed 60 days exemption that you can claim, you can also claim an exemption for days where you are actually ill. If you have got COVID-19 symptoms, so out of that test, and normally you would have to get a doctor's certificate, but that's actually probably against public policy that you go and to doctors and see them. So they did relax the rules to say, as long as you can keep evidence that you were ill, you can supplement that 60-day exemption by days you were actually ill as well. So perhaps in some cases they can, they get some extra days as well. So I'll say that, but other than to say, even this exemption, you still need to look carefully at the tax rules, because you probably are potentially going to have tax issues if you stay significant periods in the US.
Thank you.
I think mine is more of precautionary. Don't do anything until you've kind of planned ahead and thought things through and got advice. I think because some things that are coming up are people that are transiting, for example, via the Schengen area and getting caught. And so you need to be cognizant of that piece. Just kind of planning ahead. We did have one client that we've certainly had quite a few experiences where people haven't been able to board planes, and obviously that is not pleasurable. So it's just kind of knowing what people are entitled to before they actually kind of take action. And in terms of satisfactory departure, again, not leaving it to the last minute, know when your expiry dates are. I think that's the big thing with US is don't go beyond the period that you're authorised to stay.
Right. And any idea when, so your personal prediction on when the travel ban into the US might be used just for regular visa waiver business travel?
I think that's going to be linked to numbers and travel bubbles. I think if the numbers get substantially down in the UK, it might impact travel. So it's because of course it's impacting the economy for everybody. So logically, it would seem to me that there will be some review of that because it will impact tourism. For example, we obviously been focusing on business, but tourism is major for the US and vice versa. So I think that will probably drive these travel bubbles and agreements. The big thing as well that we haven't mentioned is quarantine, of course. And so it's, if the quarantine at the moment applies to the UK, it applies to the US, although it's kind of more voluntary. But some countries have entry and exit bans. So again, it's not just the immigration piece, but it's also know what the practical impact of a quarantine is as well, is really important.
And just one quick question from me, any indication or where would we look for any updates from the sort of consular teams of when those might reopen as well in the future? On the US
embassies.
sort of embassy teams.
Yeah, I mean, you can always go on a US embassy website or any other consulate if you're talking more broadly than that. It will have updates. Fragment does maintain a microsite, so you always can go in there and have a look on what it says on each country. But yeah, normally I would say always check, make sure it's a government site you're checking. So the US Embassy maintains a government site, so it will tell you whether it's possible to book appointments.
Thank you again.
Okay.
Well, Michael and Charlotte, we will sort of keep an eye on the developments from this and hope in the months ahead that we will see a relaxing of these restrictions, and that British American business, we firmly believe in the movement of business and people and talent across this border. So let's hope for a better future for that.
Yeah.
Okay. Thanks very much, Michael and Charlotte.
Bye.
Bye.